Okay, good afternoon, everyone. This is Gretchen Wall, the coordinator of the Produce Safety Alliance, and welcome to our monthly Produce Safety Educators call. I see a few people are still logging on and connecting to their audio, but we'll go ahead and get started with our introductions today and some brief announcements. The first thing is everyone who joins the meeting will be on mute through the entirety of the presentation. However, we will have some opportunity to participate in polls. So if you're logged into the Zoom meeting, we will be pausing after Stephen talks about his various court decisions, and we'll have an opportunity for some polling and a little quiz. And then at the end of the presentation, we will have time for questions. So you're welcome to enter your questions into the chat box, and we can get to them at the end of the presentation. Or at the end, we will also allow for the opportunity for you to unmute yourself if you're logged into the meeting. If you are only calling in from your phone, you can unmute your line by hitting *6 to ask a question. We will be recording this meeting, and it will be posted on our website a few days after this call. And the last quick announcement that I would like to make before we get into our presentation today is that we will not be having a Produce Safety Educators call in December, but we will pick up in January, and I will send more information out about that meeting with the presentation from today and some additional information shortly on that. But we'll be taking a break in December and coming back in 2020. So with that, I'm going to turn it over to Dr. Betsy Bin to introduce our speaker for the day. Betsy?
Thanks, Gretchen. It's my pleasure today to introduce Mr. Stephen Pevar. He's a graduate of Princeton University and the University of Virginia School of Law. From 1971 to 74, Mr. Pevar was a legal aid attorney on the Rosebud Sioux Indian Reservation. From 1976 to present, he has been a staff attorney for the National Office of the American Civil Liberties Union. Mr. Pevar has litigated some 200 federal cases involving civil and constitutional rights. His areas of specialty include American Indian and tribal rights, prisoners' rights, and free speech of public employees. One of Mr. Pevar's current cases is a class action lawsuit challenging practices in South Dakota that violate the Indian Children Welfare Act. In addition to his litigation, Mr. Pevar is the author of The Rights of Indians and Tribes. I want to stop here for a second in the middle of his bio to say that the PSA team became familiar with Mr. Pevar when we attended a training in DC in April to improve our understanding of tribes, laws that govern tribes. And so I've read parts of this book. It's a very engaging and interesting book. He also lectures extensively on the subject of Indian and tribal rights from 1983, not 18, 1983 through 1999. Mr. Pevar has taught American Indian law as an adjunct professor at the University of Denver School of Law from 2014 to 2019. He also taught at New York Law School, and in January of 2020, he will teach that course at the Yale Law School. Hopefully, some of you were on the educators call that we had last, which was the first part of this series. Roylene did a great job of starting the introduction to this series, and Stephen is going to take us to the next part, talking about 8 fascinating court decisions affecting Indians and tribes. So thank you very much, Stephen, for taking the time to be with us this afternoon.
Well, it's my pleasure, Betsy, and thank you so much for inviting me. I didn't know much about PSA, but after being invited, I went to your website, and I'm just so impressed by what you and the whole Cornell team and your purpose and your goals and how you're educating folks and farmers about produce safety. So however I can assist in the very significant work you're doing, I'm delighted to do that. You have asked me to give a presentation on 8 fascinating court decisions affecting Indians and tribes. And those of you who are listening, thank you so much for participating. This is going to be a fun exercise. If you've ever wanted to appear on Judge Judy, now is your chance. What I'm going to be doing is one at a time, we will review 8 actual cases decided by the United States Supreme Court, as each one of which established an important principle impacting American Indians and their tribes. And what I'll do is I'll explain the facts one at a time for each of the 8 cases. And then I'm going to stop at the end of the facts and ask you to guess as to how the Supreme Court actually did decide the case. And you'll have an opportunity to vote on what you think the answer is. And then I will put up PowerPoints containing quotations from the actual court decision. So it'll not only be a fun and interactive exercise, but in the process, you'll learn at least 8 very important principles involving American Indians and tribes. And by the way, I use Indian and Native American interchangeably. So here's the first case, and they're in chronological order, beginning with the oldest case first. And another way you'll be able to see to some extent how the case law developed, how these principles developed over time. All right, so the first case, 1832, Worcester versus Georgia. And here are the basic facts. Samuel Worcester was a white missionary, and he was invited by the Cherokees, who at this point had a reservation had been created for them within the state of Georgia, which was part of their Aboriginal territory. And in a treaty, they agreed to relinquish a vast amount of their Aboriginal lands in exchange for a guarantee that they would be under the protection and security of the United States government on a much smaller area within the state of Georgia. Now, bear in mind that in 1832, of course, this was prior to the Civil War, and it wasn't decided until the Civil War which government, state or federal, was supreme. And Georgia resented the fact, as did most states, resented the fact that the federal government had created an Indian reservation within Georgia. You can imagine how unpopular that was, that the federal government had essentially removed land within the state of Georgia and assigned it without Georgia's consent to the Cherokee Nation. So Georgia wanted to challenge all of that, and it passed a series of laws designed to extend its authority in Indian country within Georgia, within the Cherokee Reservation. And one of these laws said that no white person, no non-member, could enter the reservation without first getting a permit from the state of Georgia. Well, Worcester was a missionary, and he had been invited by the Cherokees to set up a church on the reservation. And he gladly accepted and moved his family to the Cherokee Reservation to set up this church. He did not get a permit from Georgia, believing that he didn't need one. And Georgia, to flex its muscle and to establish this very important point that it felt it needed to make, sent its police onto the reservation, arrested Samuel Worcester, took him off the reservation, prosecuted him in a state court, and found him guilty of violating the law that required him to get a permit before entering the Cherokee Reservation. So the issue before the Supreme Court is, did Samuel Worcester need to get this permit, or didn't he? Could he simply accept the invitation of the Cherokees and not comply with state law? So you be the judge. How do you think the Supreme Court answered this? Did the tribe win, or did Georgia win? Now, the choice that you're going to be given here is tribe or government. In this case, interpret government as state government. In some of the other cases, the issue is going to be tribe or federal government. Here, it's tribe or the state of Georgia. Please go ahead and vote. We'll give you about 30 seconds to think about this and vote whether you think the tribe won, that is Samuel Worcester won. He did not need to get a permit, or do you think the state of Georgia won?
So you should all be seeing a poll box pop up on your screen. So go ahead and cast your vote, and then we'll talk about the answer.
And of course, this is all anonymous. You know, if you make a mistake, no one's going to be able to laugh at you or anything. So, you know, take your best shot. And I could almost guarantee that no one's going to be able to get all 8 right. But if somebody does, you can start teaching this course instead of me.
So for those of you who aren't logged in online, right now the poll is showing that 38% of the people on this meeting think that the tribe won, and 62% think that the government won. So, Stephen?
Okay, so around 2/3 of you believe that the state of Georgia won, the government, and the tribe won. This is one of the most important cases, and probably is the single most important case in all of Indian law. And it established the basic principle that federal law is supreme when it comes to Indian tribes. Another way of saying the same thing is that Congress has plenary, which is a word we're going to see actually used in a case coming up, has plenary, complete, or full authority over Indian tribes. Now, here's a quote from Worcester versus Georgia. So this is an exact quote, and is written by Chief Justice John Marshall. Indian nations had always been considered as distinct, independent political communities, retaining their original rights as the undisputed possessors of the soil from time immemorial. The Cherokee Nation then is a distinct community, occupying its own territory, with boundaries accurately described in the treaty that I mentioned, in which the laws of Georgia can have no force, and the citizens of Georgia have no right to enter, but with the assent of the Cherokees themselves, or in conformity with treaties and with the acts of Congress. Before we go to the next case, I want to call your attention to 2 very important principles here. Well, 3 really. One is that tribes do retain their original rights. Second, that states have no authority in Indian country unless the Cherokees, unless the Indians themselves invite the state, or Congress gives the state that approval. Okay, so keep that in mind, those principles in mind. And by the way, I mentioned that this was written by Chief Justice John Marshall. Marshall was our fourth Chief Justice, and he was the Chief Justice for close to 40 years. And because he was on the court for so long, at an early stage, he is probably the single most important chief or justice that we have had, because he created so many principles that stole govern our nation. And Worcester versus Georgia is one example. All right, next case. Ex Parte Crow Dog, 1883. So some 50 years after the Worcester case. This case took place on the Rosebud Reservation, the reservation that I wound up living on, about 90 years later, working as a legal aid lawyer. And here are the facts. Crow Dog was a chief, an important person for the Rosebud Sioux. And he murdered another important chief named Spotted Tail. And there wasn't any doubt about it. There were witnesses. Crow Dog immediately acknowledged that he and Spotted Tail had had this terrible argument, and that Crow Dog killed Spotted Tail. So his, quote, guilt or innocence was not the issue. The issue was punishment. What happened was that virtually every Indian tribe in the United States practiced what is called restorative justice, which is very different from Anglo-American principles of retaliation and retribution. Anglo-American law created prisons, created capital punishment. If somebody misbehaves, they're normally segregated from society and they're punished in some way. That wasn't the traditional way that Indian tribes dealt with misbehavior. They believed in community healing. What they typically did, and what happened here, is the families got together, elders were invited to participate. No one excused or condoned the terrible event that had occurred, but the community recognized we need to figure out a solution so that we can heal and continue on as a community as best we can. And the result of these meetings was for the Crow Dog family to essentially adopt the Spotted Tail children, to feed them, clothe them, provide for them. The Crow Dog family gave the Spotted Tail family horses, blankets, foods, and agreed to protect them over time. And the community felt comfortable with that. And that was the solution that the community and the families came up with. Well, unfortunately for the Rosebud Sioux at the time, a newspaper reporter from a large paper out east was visiting that reservation and saw what had happened and totally misconstrued the result. And he wrote back in an article that was distributed widely on the East Coast, and he depicted this solution as Indians getting away with murder. I mean, that is literally how it was described. And nothing could have been further from the truth. But it inflamed the white people in the East, believing that there was lawlessness on the reservations. So the president was actually pressured to send U.S. Marshals to the South Dakota Territory. This was, or Dakota Territory. This South Dakota was not a state as yet. They arrested Crow Dog and they prosecuted him for murder in a federal territorial court. There was at the time laws that made it a capital crime to murder anybody on what was known as a federal enclave, which included a national park, a national forest, a military base. And the government prosecuted Crow Dog, telling the court that Indian reservations should be viewed as federal enclaves. And because murder is a crime on federal enclaves, we have the authority to arrest and prosecute Crow Dog. The federal trial court agreed, found Crow Dog guilty, and sentenced him to hang. He appealed his conviction to the United States Supreme Court, and the Supreme Court accepted the case. And I use the word accepted because today the Supreme Court is asked to take about 8,000 cases a year, and they accept about 80. So there's a 1% chance. I don't know how many cases were submitted to the Supreme Court in 1883, but the Supreme Court, I'm sure back then, also took a very small percentage. Nevertheless, they accepted this case. And what Crow Dog argued and what the tribe argued is that although there was, of course, this general criminal statute that made murder a crime in enclaves, there was nothing in that statute that expressly applied that law to Indian tribes. And therefore, these tribes, the Crow Dog argued, were exempt from that law. Congress has the plenary power, the exclusive authority to make laws applicable to Indian tribes. This general enclave law did not do that, and therefore Crow Dog had to be released. So how do you think the Supreme Court ruled? Essentially, did Crow Dog die? Was he hung as the trial court ordered, or did the government win? Did the tribe win or the federal government win? Who do you think won that case? And you have 30 seconds to register your vote.
All right, looks like a few people still haven't voted, but give it 10 more seconds to get your vote in, and then we'll show you the results. People are changing, and this is really interesting to see from my end. People are going back and forth, changing their minds.
Now, just because 2/3 lost last time, no reason not to vote.
Okay, there's the results on the screen. Looks
Okay.
like we have 32% people said tribe and 68% said government.
All right. Well, the tribe won. And I'll put a quotation in just a moment. Essentially, what the Supreme Court did is what it did in Worcester versus Georgia. It said that Congress has final authority. Congress could make these criminal laws applicable to tribes, but because it had not expressly done so, then those criminal laws were inapplicable, and the tribe had the inherent right to decide for itself the Crow Dog's punishment. So here's a quotation from the actual case. Our government has always recognized the Indians as exempt from our laws, and in regard to their domestic government, left to their own rules and traditions. To uphold the jurisdiction exercised in this case would be to reverse, in this instance, the general policy of the government towards the Indians, as declared in many treaties and statutes, which is independence. To justify such a departure in such a case requires a clear expression of the intention of Congress. And that we have not been able to find. So this is essentially Worcester versus Georgia. Worcester versus Georgia said that states cannot impose their laws in Indian country unless Congress has expressly authorized it. Ex parte Crow Dog says neither can the federal government impose its laws in Indian country unless Congress has expressly authorized it. As an important footnote, 2 years later, Congress passed a law that essentially what in our terms might be called legislatively overruled Crow Dog. It enacted the very law that the government wished it had when it arrested Crow Dog. And it's called the Major Crimes Act, which still exists today. And in that law, the MCA, the Major Crimes Act, that law expressly confers federal court authority to arrest Indians who commit one of these major crimes, and there's close to 20 or so today, in Indian country against anyone else on an Indian reservation. But that took a special act of Congress, and no such MCA existed at the time, and therefore Crow Dog was released. Next case, Talton versus Mays. Now, some of you who are familiar with American history, particularly our history dealing with Native Americans, might know that one of the more shameful, in my opinion, things that occurred is that beginning in the 1830s with the election of Andrew Jackson and continuing after that, a move was made to forcibly remove the tribes in the East, particularly in the Southeast, to a new area that had been carved out in the West, known as Indian Territory. Indian Territory was a barren, windswept area that is now Oklahoma. But in the 1830s and 1840s, the federal government believed no one would want to live there. And Congress created this area, and it became a dumping ground for Eastern tribes. Today, there's some 35 federally recognized tribes in Oklahoma. Only 4 of them are indigenous. The rest were forcibly removed there. One of the tribes that was forcibly removed were the Cherokees, the same tribe that was involved in Worcester versus Georgia. They were marched literally at bayonet point, and many of them had to walk from Georgia to Oklahoma in what's known as the Trail of Tears. And some 15,000 members of this tribe died during that forced march. I mean, I can't even imagine walking from Georgia to Oklahoma through every type of weather that there is. No wonder so many died. All right, so this case takes place on the Cherokee Reservation in Oklahoma in 1896. The federal government, in addition to moving the Cherokees, created or helped the Cherokees create a governmental system, including a court system. And this court system had capital punishment. What happened here is Talton was a member of the Cherokee Nation. He murdered another Cherokee. He could have been arrested by the federal government under the Major Crimes Act, which I had just mentioned. But instead, he was arrested and prosecuted by his own tribe. He was prosecuted in a Cherokee tribal court, found guilty of murder, and sentenced to hang. The Cherokees now had capital punishment. He asked the U.S. Supreme Court to review his conviction, and here again, the Supreme Court agreed to accept his case. Talton argued that under the Fifth Amendment, all of us have a number of rights, one of which is due process of law. The Fifth Amendment grants all of us the right not to lose life, liberty, or property without due process of law. Talton argued that some of the procedures that he was subjected to in a tribal court violated his Fifth Amendment right to due process. And there wasn't any question about the fact that at least one of those procedures would have been different had he been prosecuted in a state or federal court. And that procedure was the right to a grand jury indictment. The Fifth Amendment also guarantees that you and I cannot be indicted, especially for a capital offense, unless there's a grand jury indictment. So Talton argued that because he would have received that procedure in a state or federal court had he committed this crime off the reservation, his conviction violated the U.S. Constitution. Stated differently, he argued that he had federal constitutional rights in a tribal court. The tribe argued, however, that they are inherent sovereignties. They can have their tribal courts however they wished. They do not have to comply with the United States Constitution. Talton did not have constitutional rights in a tribal court. He may have those rights and does have those rights in a state or federal court. He does not have those rights in a tribal court. The tribal court can operate its system however it wants. How do you think the U.S. Supreme Court decided that case? Did the tribe win and they could have their tribal courts however they wished? Or did Talton win, and in this case the government win, that tribal courts must comply with the United States Constitution? That indeed every Indian tribe is beholden to and must comply with the United States Constitution. Who do you think won? So in this case, Talton would be government. So it's either tribe or Talton who would win.
Okay, we'll give you another 5 seconds to get your vote in, and then we'll take a look at the results. Alrighty. Ooh, this one was a close call. We got 45% of people saying the tribe and 55% saying government.
Okay. The tribe won yet again. So 3 cases in a row now. The tribe won on the very same principle established in Worcester versus Georgia. In fact, here's a quote from the Supreme Court's decision in Talton, and as you'll see, the court harkens back to Worcester. It cannot be doubted, as said in Worcester, that the Indian nations had always been considered as distinct, independent political communities, retaining their original natural rights. Because the powers of local self-government enjoyed by the Cherokee Nation existed prior to the Constitution, they are not operated upon by the Fifth Amendment. So in Worcester, state law did not apply. In Crow Dog, federal law did not apply. In Talton, even the United States Constitution was held to be inapplicable to tribal government a fairly shocking result when you stop and think about it. It meant that there literally were pockets within the United States that did not have to comply with the United States Constitution. Now, as a quick footnote, I mentioned in Crow Dog that it only took 2 years for Congress to legislatively overrule Crow Dog. It took Congress about 70 years here, but Congress ultimately legislatively overruled, at least in a major extent, Talton. And in 1968, Congress passed a law known as the Indian Civil Rights Act, ICRA. And that law, by statute, imposes on tribes and tribal courts nearly all of the limitations imposed on state and federal courts by the United States Constitution. Now, it's still true today that tribal members, or you, if you're in a tribal court, do not have federal constitutional rights. You cannot say, tribe, you violated my rights under the U.S. Constitution, because you don't have any. What you do have, however, are statutory rights, legal rights, under the Indian Civil Rights Act of 1968. And Betsy was kind enough to mention my book. If any of you have the book or might get it, chapter 14 of my book is entitled The Indian Civil Rights Act, and I explain ICRA in more detail. All right, next case. Lone Wolf versus Hitchcock. And this is not even 10 years after Talton versus Mays. And here are the facts. Because in our early history, Indian tribes were viewed as independent nations, as we've seen in the last three court decisions, the natural way that our government negotiated with Indian tribes was by treaty. That's the way that the United States always negotiates with independent nations, by treaty. So it was, of course, the way that we negotiated with tribes initially. They were viewed as independent nations, and today most tribes believe that they continue to be independent nations. However, in 1871, Congress, in a historic change of policy, refused to identify Indian tribes as sovereign nations and passed a law saying that there will be no more treaties with Indian tribes. And that's why we do not have them today. The last treaty was signed in 1871. This case involves a treaty that was written in 1867, so 4 years before the end of treaty making. 3 tribes in Kansas, the Kiowa, the Apache, and the Comanche, signed a treaty with the federal government. Now, these tribes had watched what had happened to so many other tribes that had placed their trust in the federal government and signed treaties, where the tribes fulfilled their end of the bargain and the federal government quickly broke the treaties. Virtually every treaty that we have ever signed, and there's nearly 400 federal treaties with tribes, virtually every one has been broken. Usually, the way it was broken is a area of land was set aside for the tribe for as long as the sun shall shine and the river shall flow. And then as whites began moving out into that territory and wanted that land, the federal government simply took it. Well, here, these 3 tribes came up with what they thought would be a brilliant protection. And they insisted in their treaty of 1867 that the federal government agree, which it ultimately did, the federal government agree that no additional land would ever be taken by these from these three tribes unless the federal government held an election on the reservation and 3/4 of the tribal members agreed to relinquish additional land. Now, the tribes were confident that were such an election to be held, tribal members would never agree to give up more land. All right, so 1867, the federal government signs that treaty and the Senate ratifies it. Sure enough, as what happened with every other treaty, whites start moving into this area in Kansas, and they want a big chunk of that treaty land. The federal government holds the election that was required by the treaty, and the removal was defeated, soundly defeated, as the tribes had guessed in the beginning. Tribal members were not willing to relinquish their land. It is now the end of treaty making. Congress doesn't have to get the tribes' consent any longer. So what Congress does is it passes a law taking 2/3 of the land anyway, in direct violation of the treaty. There was no question about the fact that the United States had pledged its solemn word to these tribes. If you end your warfare and agree to reside on a much smaller reserve than are your Aboriginal lands, we will never, ever take away the remaining territory unless we hold this election and you vote in favor of it. But now the federal government goes back on its word. And when the tribes refused to relinquish the land, Congress took it anyway. Lone Wolf was a Kiowa chief. Hitchcock was the Secretary of the Interior at the time. Lone Wolf filed suit against Hitchcock to invalidate that statute and to get the land back. Who do you think won? Did the tribe win and the Supreme Court invalidated the law and said that that land cannot be taken unless consistent with the treaty? Or did the government win and the Supreme Court held that Congress can abrogate, that is, violate the treaty, break the treaty, and take the land simply by passing a statute? Who won? And you have 30 seconds.
Okay, it looks like everyone's just about done voting. And it looks like 21% said the tribe won and 79% said the government won.
Well, the majority won this time. Good job. Lone Wolf versus Hitchcock for American Indians is probably the most reviled decision of all time. There are a couple that are equally as detested as Lone Wolf, but this is up there. Because essentially what Lone Wolf holds is that the United States can break its promises to Indians anytime it wants. It doesn't matter what promises we make to Indians, what the Indians did in reliance of those promises, the fact that these tribes did everything that the government asked them to do. They've totally fulfilled their treaty, and yet the federal government turned its back and violated that treaty. And here are quotations from the Supreme Court's decision in Lone Wolf. First, the Supreme Court emphasized that Congress has plenary power. And I'm quoting, "Plenary authority over the tribal relations of the Indians has been exercised by Congress from the beginning. The power exists in Congress to abrogate the provisions of an Indian treaty." So the Supreme Court gave unfettered license to Congress to do whatever it wants with respect to Indian treaties. The tribe had argued that the government must keep its word. Here's one argument given by the Supreme Court to that. In view of the legislative power possessed by Congress over treaties with Indians and Indian tribal property, we may not, the court may not, consider if Congress did the right thing. These matters are solely within the domain of the legislative authority, and its action is conclusive upon the courts. In other words, the Supreme Court, took a hands-off attitude. Oh, Congress gets to make these decisions, and we cannot even review them. There was at this time, and there still is, a principle known as bad faith, that if the government acts in bad faith towards the tribe should win. And Lone Wolf made that argument here. Here's what the Supreme Court answered. We must presume that Congress acted in perfect good faith. So the court just simply gave Congress a blank check, saying that we're just going to presume that Congress is always acting in the best, for the best interest of the tribe. Therefore, your loss of 2/3 of your reservation, you may not realize it yet, but that's really in your best interest. So under today's analysis, and this is still the rule today, Congress breaks Indian treaties on a regular basis, and Lone Wolf versus Hitchcock gives Congress the authority to do that. Next case, Winters versus the United States. Here are the basic facts of this case. The Winters case involved tribes in Upper Montana, and the president established a reservation for tribes up there. And the northern boundary of the reservation was the Milk River. The Milk River is an important watershed in that area. The tribes that lived up there had traditionally obtained fish from the river. A number of the tribes were agrarian and had produce, had farms in that area, and relied on the water from the Milk River. Well, the executive order that created that reservation and it's the Fort Belknap Reservation today, was silent as to water rights. This was not unusual. Many treaties out west were signed, or executive orders creating reservations, and I should say an executive order, as the name implies, is an order by the President of the United States. Many reservations were created by the chief executive, by a president, through an order, and it's known as executive order. All right, so, and that was true of the Fort Belknap Reservation. Back then, because there were so few non-Indians who lived in that area of the country, many of these treaties or executive orders didn't guarantee things like hunting rights or fishing rights or water rights, because the supply seemed virtually inexhaustible and there was no competition. So here again, this executive order didn't say anything about guaranteeing water rights. Well, in the next 30 years, non-Indians flooded this area in droves. And many of them settled upstream on the Milk River. Those farmers and ranchers, in perfect good faith, invested their life savings in these farms and ranches. And they started appropriating water from the Milk River, taking water now that was going to be used downstream by the tribes that occupied the Fort Belknap Reservation. Some of you may be aware that west of the Mississippi River, as settlers began moving west, and they learned for the first time that water was short out west, not like in the east where it is so plentiful. They needed to establish a rule of law to avoid warfare over this scarce resource. And the doctrine they came up with is known as the Doctrine of Prior Appropriation. And it's now in law codified in every state west of the Mississippi River. And what that law says is that whoever takes water first is allowed to continue to take the same amount of water forever, as long as they register their claim. In other words, first in time, first in right. By establishing that rule, it prevented people literally from killing themselves over water. If you registered your claim and you were entitled to 10 acre feet of water a year, then you could always get your 10 acre feet of water. And you could take your 10 acre feet even if not a drop was left for anyone who is a junior interest. So there are senior interests and there are junior interests. Well, all of the people who settled along the Milk River followed state law. They registered their water claims, and people knew who had the paramount right to take water. I emphasize again that the reservation was silent as to water rights, and the tribe never registered a claim. As the years went on, so many non-Indians began siphoning water out of the Milk River that there was not enough water for the tribe to irrigate their lands. The United States sued on behalf of the tribes, and they sued these water users, one of whom was named Winters. So this began as the United States versus Winters and some 30 other families who were also taking water out of the Milk River. Here was the issue before the Supreme Court. Did Winters' water rights, were they superior to the tribe's rights? Because again, Winters had complied with state law and had in perfect good faith removed only that water that was left for him after senior interests had taken their share. And he did so, and he invested his life savings based on who had the senior interests. The tribe had not registered any claim, therefore he invested his money in that ranch, believing that he had a right to take the water that he did take. The government argued, on the other hand, that whenever the federal government creates a federal reserve, whether it be an Air Force base, an Army installation, a national park, a national forest, a national monument, anytime it creates a federal enclave, it impliedly reserves enough water to satisfy the purpose of that reserve. The government does not have to register a water claim, but everyone else does. Who do you think won? Did Winters win because he fully complied with state law and he took the water that was entitled him under state law, or did the tribe win on this notion of an implied right to water because the federal government had created a reservation for these tribes. So in this case, although it says tribe government, please interpret government to mean Winters and the non-Indians. So did the tribe win or did the non-Indians win?
Well, it looks like this is going to be another close call, so get in your votes. I'll give you 10 more seconds, and then I'll share the results of the polling. Okay. Looks like it was pretty close. 55% said tribe won, and 45% said the government won.
Okay, the tribe won. Some of you may be familiar with the Winters Doctrine. It's the single most important doctrine in all of water law, and it comes from this case. And the Supreme Court held in Winters that each and every time the federal government creates a reserve, again, whether it's a military base, a national forest, or an Indian reservation, it impliedly sets aside enough water to satisfy the purpose of that reserve. So here are some quotations from Winters. First, the court actually asked a rhetorical question. The Indians had command of the lands and the waters prior to agreeing to move to the reservation. Did they give up all this? Because that would have been what the non-Indians were arguing, that they simply gave up their right to water. And what the court answered was this: by a rule of interpretation of agreements and treaties with the Indians, ambiguities occurring will be resolved from the standpoint of the Indians. And I'll have more to say about that in a second. And the rule should certainly be applied to determine between two inferences, one of which would support the purpose of the agreement and the other impair or defeat it. The two inferences that the court is talking about here is, was water rights inferred or not? If they're not inferred, that would defeat or impair the reservation. The tribes could not live there, and yet the federal government had created a reservation for them. Winters helped create what is known as the Reserved Rights Doctrine. This is what is the court is referencing by a rule of interpretation. This is the rule of interpretation the court is referring to. This is one of the most important principles in all of Indian law. You do not read a statute or an executive order or treaty to find out what rights tribes have, although some of these treaties do provide certain rights. Rather, you read them as follows: all of the rights that Indians historically had are presumed to be retained by the tribe unless the treaty removes those rights. So a treaty, in other words, should not be interpreted as a giving of rights to a tribe, but a taking of rights from them. And any rights that the tribe would traditionally have remains with the tribe unless it's removed. So yes, this executive order was silent as to water rights, and that means the tribe retained its water rights. It didn't need to have an actual conferral of water rights in the executive order. It's presumed that they retained them because silence means that they did not give all that up. Okay, we have 3 cases left, and I'm going to need to move pretty rapidly. through these three. The next one is Sandoval, United States versus Sandoval in 1913. And here are the basic facts. As some of you know, the United States obtained what is now portions of California, Texas, and New Mexico from the Mexican government in the Treaty of Guadalupe Hidalgo of 1854. The Mexican government was very protective of the indigenous peoples of the territories it was giving up. And with respect to almost all of whom, especially in New Mexico, had converted to Catholicism, as the Spanish were and as the Mexicans were. The Mexicans were so desirous of protecting these pueblos, there were 19 and still are 19 pueblos in New Mexico, that they insisted that the United States agree in the Treaty of Guadalupe Hidalgo to recognize the land rights that the Mexican government had given to these pueblos. The pueblos owned their land under the Mexican government, and the Mexican government insisted that the United States government recognize those land rights, which we agreed to do. Well, Sandoval was a member of one of those pueblos. He brought liquor onto his own reservation. There already was a federal law that made it a crime for anyone to bring liquor into Indian country anywhere in the United States. Sandoval argued that law cannot apply to me because of the Treaty of Guadalupe Hidalgo. The treaty superseded that federal law. I have rights under the Treaty of Guadalupe Hidalgo, in which the federal government recognized the continued independence of the pueblos. So the issue in this case was whether or not this federal law did or did not apply to these independent, essentially independent nations or governments on in New Mexico, these 19 pueblos, or did the federal government take the position, or I should say, the federal government took the position that despite the treaty, every Indian tribe was under and all Native Americans were under the government, under the authority of Congress. And when Congress passed this law, it applied to the pueblos the same as all other Indians. Who do you think won? The tribe or the government?
Okay, we'll give you another 5 seconds to get your vote in. Some people switching back and forth again, but it looks like this one definitely, oh, maybe not. I was gonna say, it looked like it was going in one direction, then a bunch of people look like they changed. Okay, I'm gonna end the polling. Looks like 35% of you voted that the tribe won and 65% voted that the government won.
All right, the majority won again. Now, I debated whether to include this case because of the quotations, because of what the Supreme Court said in Sandoval. Literally hold on to your seats. Remember that this is the United States Supreme Court. Look at the language that our Supreme Court used in justifying the imposition of these liquor laws onto the pueblos. Bear in mind, I mean, you would never see language like this, and I trust never will, ever again. But it does reflect, sadly, the prevailing attitude that our government and our society had towards Native Americans in 1913. Here's the language. The people of the Pueblos are a simple, uninformed, and inferior people, requiring special consideration and protection like other Indian communities. They are dependent upon the fostering care and protection of the government, like reservation Indians in general. They are intellectually and morally inferior and are easy victims to the evils and debasing influences of intoxicants. And the court went on to say, not only does the Constitution expressly authorize Congress to regulate commerce with the Indian tribes, but the United States, as a superior and civilized nation, has the power and the duty of exercising a fostering care and protection over all dependent Indian communities. Well, one thing that I just want to point out, I'm sure all of us have a visceral reaction to this, but the phrase at the bottom, and the duty of exercising a fostering care. This was the prevailing attitude for almost 200 years of our history, that we have a duty to protect, to legislate over, to control, to regulate Native Americans because they're too dumb to know what's in their best interests. And this case is one of, but unfortunately is not the only example of how Native Americans were viewed during this period of our history. Next case, Ola Fans versus Suquamish Indian tribe. So this is now some 70 years later. Here are the basic facts. The Suquamish Indian tribe is a small tribe in northern Washington state. And like most tribes, every year it has an annual powwow. During this powwow, Ola Fans was a non-Indian. He got drunk and he went to this powwow on the Suquamish Reservation, started interfering with the dancers on the powwow grounds, the parade grounds. When a tribal officer went up to him to escort him off the grounds, Ola Fans punched him in the face. He then got into a car and started weaving down tribal roads. It's a miracle he didn't kill anybody. And he was stopped only when a tribal officer rammed his car into Ola Fans' car and forced him off the road. Tribal police then arrested Ola Fans for violation of various tribal laws. He was prosecuted in tribal court. Now, this is after the Indian Civil Rights Act of 1968, so Ola Fans could claim protections under the Indian Civil Rights Act. He was found guilty and sentenced to tribal jail for violating tribal law. He asked the U.S. Supreme Court to review his conviction. And his argument was that Indian tribes lack inherent authority to prosecute non-Indians. In the Supreme Court, the tribe argued essentially Talton versus Mays, that Indian tribes are presumed to retain all of the rights that they historically have had unless Congress removes such a right. Congress had never removed a tribe's right to prosecute non-members. Therefore, it has to be presumed that that right remains, and that therefore they have the inherent right to prosecute Ola Fans. Who do you think won? The tribe could prosecute this non-Indian, or, and in this case it says government, but you should presume it means Ola Fans. Did Ola Fans win and the tribe had to release him? Or did the tribe win because Congress had never passed a law removing or relinquishing or inhibiting, limiting any Indian tribe from prosecuting any lawbreaker within tribal land?
Okay, we'll give you another 5 seconds to get your votes in. Like people made up their minds. Oh, one or two changing. Okay, let's look at the results. Looks like 66% of you thought the tribe won and 34% thought government won.
Okay. Well, before I give you the answer, let me mention one thing. During our history, by and large, the president and Congress have been the worst enemies of tribes, and the Supreme Court, by and large, has been the friend of tribes. Some of the cases that we have just reviewed, you know, Ex Parte Crow Dog, Worcester, Talton, where many of you believe that, well, of course the tribe lost, the tribe won. Overall, the Supreme Court has been more of a friend to tribes than Congress. It's been Congress that has passed these laws breaking the treaties. It's been the president that has led that effort. In the last 50 years, that has been reversed. Today, and the some of the laws that you guys are familiar with in agriculture are examples of laws that Congress has passed to help support tribes. Congress has probably created at least 50 programs in the last 40 years that have sought to help Indian tribes. At the same time, the United States Supreme Court is now the worst enemy. A law professor recently wrote an article reviewing court decisions over the last 40 years and found that Indians and tribes have lost 80% of those cases. No group has a worse record before the Supreme Court in the last 40 years than Indians and tribes do. This is one of those early decisions that changed the tide. One reason why so many of you believe that the tribe won is because, frankly, the tribe should have won. If the Supreme Court kept to its earlier principles, the Suquamish would have won. I was careful to mention that Congress had not passed a law limiting tribal authority to arrest non-Indians. Under the principles that we have discussed for the last 150 years, that means that the tribe should have been found to have kept those rights. What the Supreme Court wanted to do, clearly, is to reach the result of not permitting tribes to arrest and prosecute non-Indians. This was, in the opinion of many people, a very racist decision. The Supreme Court did not like the idea that tribes could determine the liberty of non-Indians. And therefore, it had to come up with a different principle. because if they used the principle that it had created for the last 200 years, that tribes retain those rights unless they're expressly removed by Congress, it would have had to rule in favor of the Suquamish. It didn't want to do that, so it came up with a new principle. And here are some quotes that help us see what that principle was. The tribe argued that its authority to prosecute non-Indians flows automatically from the tribe's retained inherent powers of government. The tribe pointed out that no federal law prohibited the exercise of this power. What the court said is, Indian tribes are prohibited from exercising both those powers of autonomous states that are expressly terminated by Congress. And there used to be a period there. But the court added, and those powers inconsistent with their status. What the heck is that? Now, the plenary power doctrine is not being decided by Congress, it's being decided by a judge. It's a judge that now has the authority to determine what power is inconsistent with the status of a tribe. The court went on to hold, Indian tribes do not retain the power to try non-Indians according to their own customs and procedure. And by the way, the court dropped this as a footnote. The court noted in footnote 1 that approximately 3,000 non-Indians live on the Port Madison Reservation, which is the Suquamish Reservation, and 50 Indians. So the Supreme Court made special note of this, and everyone reads between the lines saying, we did not want to give this small tribe or the small reservation with only 50 Indians power over 3,000 white people or non-Indians. So this is an example of how the Supreme Court has stood on its head, has changed tried and true principles. And I could give you numerous examples of how the Supreme Court has gone back on principles created over the last 150 years. All right, there's one last case. United States versus Lara. Now, here are the facts. First of all, we know from the Ola Fans case that we just examined that Indian tribes do not have the inherent authority to prosecute non-Indians. In a subsequent case called Duro versus Reyna, the Supreme Court addressed the question, okay, you don't have jurisdiction over non-Indians. What about non-member Indians? That is, someone who's an Indian, but who is on a reservation other than her or his own. That is a non-member Indian. So like a Navajo visiting a Sioux reservation, who then engages in an act that violates tribal law. What side of the fence, what side of the Ola Fans fence does that person fall on? Do tribes have the right to arrest and prosecute those people or not? That was decided in Duro versus Reyna. And in that case, in 1990, and in that case, the Supreme Court held that non-member Indians fall on the Ola Fans side of the case. Indian tribes don't have that authority either. Well, less than a year later, Congress passed a law known as the Duro Fix. And Congress says in that law that Indian tribes do have the inherent authority to arrest and prosecute non-member Indians. Lara was a non-member Indian. He was arrested by an Indian tribe other than his own. He was visiting someone else's reservation, and he asked the Supreme Court to rule that the Duro fix was unconstitutional. This presented a fascinating issue before the court, because the court had just ruled that tribes don't have that inherent authority, and now Congress says they do. Who prevails in a situation like that? Who has the final word? So what do you think the Supreme Court ruled? Did the tribe win? They were allowed to prosecute Lara, or did Lara win? Here it says government, but please understand government meaning Lara, that Congress cannot change what the Supreme Court has ruled regarding inherent tribal powers.
Okay, we'll give it 10 more seconds to get your vote in for the last question of the day. I think this one is challenging some people.
It's a challenging issue.
That's interesting because the other ones have been so easy.
Yeah.
All right, let's take a look at it. Ooh, we've got an even 50-50 split.
Wow. Wow, interesting. All right. Now, I was careful to say when I was explaining the case that the Supreme Court had ruled that tribes lack the inherent authority, and Congress then passed a law saying, no, tribes do have the inherent authority. I did not say that the Supreme Court ruled it would be unconstitutional for tribes to exercise that authority, just that they lacked the inherent authority. If the Supreme Court had said that something was unconstitutional, Congress cannot change that. It would require a constitutional amendment. However, what the Supreme Court said in Lara was, because we had ruled in Duro versus Reyna that tribes lack the inherent authority to do it, Congress has the final word. Congress has plenary power. We don't. And it's Congress that determines whether a tribe does or does not have the inherent authority to do something. So in a fascinating, again, decision, here's what the court said, that Congress does have the authority to essentially overrule us on any matter that does not involve the interpretation of the Constitution. So the court said the Supreme Court's decision in Duro versus Reyna did not set forth constitutional limits that prohibit Congress from changing the relevant legal circumstances, i.e., from taking actions that modify or adjust the tribe's status. The rule announced in Duro, the court pointed out, was judicially made and not required by the Constitution. Therefore, Congress can change it because Congress has final authority in Indian affairs in such situations. So it was a rather rare instance in which the U.S. Supreme Court placed a limit on its own authority and said that even some decisions that we make can be overruled by an act of Congress. All right, well, I didn't leave quite as much time as I had hoped. I don't know, Betsy and Gretchen, whether we need to end exactly 3:30 or not. I suppose some people can leave if they need to, but I'd be happy to stay and answer some questions, however you wish.
Yeah, we do have a call, but I want to see what the questions are, because while we've got you here, I want to take advantage of this opportunity. So let's see if people have any questions. I thought it was a very good presentation. I think, as I jokingly said about this last one, it's complicated, and I think you did a very good job of explaining, you know, where the intricacies are, where maybe the Supreme Court varied in past cases moving forward, and certainly the difference in how tribes have been treated, you know, President and Congress versus the Supreme Court. I thought that was very interesting.
Yeah. And
So
you
if
could
you
see,
have, go ahead.
sorry, no, go ahead.
No, I was going to say, if anybody has questions, there's the chat box. There's also the Q&A box, or you can, I might even be able to raise your hand. So
Yeah,
we can unmute you.
the one thing I was going to mention is you could see how difficult federal Indian law is. When I went to the reservation in 1971, there was only one law school that was teaching federal Indian law, the University of New Mexico. And I didn't go to that school, so I didn't take federal Indian law. And I made many of the same mistakes that you guys did. You know, I interpreted issues being presented to me by my clients the same way as you did, and I made a mistake. I am, you know, embarrassed, deeply sorry. One reason I wound up writing the book is because I was hoping to have other people avoid making the same mistakes that I did by using, you know, white man's law with respect to American Indians, and that is not the way that many of these issues should be viewed.
And I think this presentation combined with what we heard from Eileen is so interesting when you think about not only the legal but the cultural side of things. It hopefully starts to draw a picture of really how much there is to know and how much there is to learn, and some of the challenges that could be out there. We do have a question. Do you have a theory for why the switch to more recent courts not supporting Native Americans while Congress became more likely to support them?
The only theory really that anyone has is simply a change in personnel. You know, all of us have prejudices, biases, opinions, and it seems to be the case, fortunately or unfortunately, that the vast majority of people on the Supreme Court today are what many view as just anti-Indian or anti-tribe. Many of the decisions that went against tribes were 9-0 decisions. I mean, not even close. Whereas today, there's a growing perception of members of Congress. Now people who are in Congress, of course, are more responsive to voters, and in general, public opinion is more favorable to Indian tribes. And Indian tribes too, and Indian people, although they're only less or around 2% of the population, they have changed elections. They have made a difference in elections in a number of close races. So there are members of Congress who are more desirous of helping tribes and making sure to get the tribal vote. And also, most of us in society today, or many of us, are more pro-Indian than we used to be, more sensitive and understanding of the difficulties facing Indian tribes and want to help them. And I think that that's reflected in who we're electing, who's in Congress, and who are on the Supreme Court. A very good question, and different people have different answers to that question.
Thanks for that answer, Stephen. Can you address the impact of all of this on produce safety rule compliance on reservations by Native American growers? You don't have to feel compelled to answer that, because I'm not sure how much you know about the produce safety rule. But if you know something about it, do you have any idea the impact?
You know, I'd hate to say something and be wrong. Also, I'm sure it varies from reservation to reservation, both in terms of some reservations are more traditional, some reservations are more suspicious than others, some have had worse dealings with the federal government than others. So I'm sure that it varies considerably, and I'd hate to guess wrong. I don't know the answer specifically, and maybe some of you do.
Yeah, can we maybe take a step back and just say in general, federal laws that are made in the U.S., are tribes subject to those federal laws on tribal lands?
Well, as we saw in Ex Parte Crow Dog, no, they're not, unless Congress has placed something in the law expressly making it applicable to tribes.
Okay.
However, Congress is so aware of that rule that many, if not most, of statutes today involving general laws have a provision either saying that it is or is not applicable to Indian tribes. Those statutes that don't have any express application have presented difficult questions for courts. And one thing that I actually discuss in chapter 5 of my book is I go through a number of these kinds of statutes, like the Bald and Golden Eagle Protection Act. Interestingly enough, did not have a provision stating whether it was applicable to tribes. And many tribes have treaty rights allowing them to take eagles and eagle feathers. That case went to the U.S. Supreme Court, and the Supreme Court said that because it was clear that Congress addressed this issue in committees, and it was understood that tribes would have to comply with that law, we are going to interpret it as applicable to tribes, even though, as I mentioned, there isn't anything expressly restricting those treaties. So often it is a case-by-case basis, and there is no way that I could answer that yes or no. But the general rule is that unless it's expressly applicable to tribes, then it's not applicable.
Okay, thank you. I don't see any other questions, which might mean that people are just, maybe their brains are full from all of the information you shared. I know I've heard this before, and I still found it fascinating to think about and to see what I remembered previously. But it really is very complex, and I'm hoping that people have gotten a lot out of this series of 2 webinars, in the sense of learning what questions to ask, where they might find additional information, and what are important things when we are trying to help tribal members and help them understand parts of the rule, or even risk assessment in terms of risk. So I really appreciate your time today, Stephen. It was very, very good. And I now see that Gretchen has put up the next meeting slide. So yep. Gretchen, you want to go ahead and take care of that?
Yeah, just a couple quick wrap-ups. So first, I'd like to say, Stephen, again, thank you for your presentation. I actually received several text messages while you were presenting, people going, what? Oh my gosh, this is crazy. So definitely fascinated several people that were listening in on the call today. So again, thank you for your presentation.
And by the way, just very quickly, in further response to an earlier question, the 2018 Farm Bill has several provisions applicable just to Indian tribes, or provisions that make other provisions of the Farm Bill applicable to Indian tribes. So Congress is well aware of this issue, and there's a number of bills, including the 2018 Farm Bill, that Congress has made and given tribes particular rights under these various laws.
Thank you for
Great,
that.
thanks. Yeah, thanks for sharing that.
Yeah.
So just wanted to reiterate, we're not going to have a meeting in December, so happy holidays to everybody. And our next tentative meeting will be on Monday, January 13th at 2 p.m. Eastern, and we'll have Mr. Jeff Davis, who's the Business Development Specialist with AMS Specialty Crops Program, talk about some of USDA AMS programs. I also had two quick things. If you guys hadn't seen these come out in our newsletter, we are hiring. We actually have a Southeast Regional Extension Associate position to replace Dr. Kristen Woods, who we're very sad has moved on back to Alabama. So we'll be rehiring her position. And then we're hiring another Spanish language extension associate. So those were listed in our newsletter. You can also find those on our website and through the links on this slide. And we are currently reviewing applications, and we'll continue reviewing applications until we find the right candidate for each one of those positions. And then lastly, just to remind everybody, because this is our educators group, we are collaborating with the FSMA Southern Center on hosting some PSA advanced trainer workshops. So we're hosting 2 courses. You can choose to go to one of those courses. So the first is upcoming on December 17th through 19th. And the second is January 28th through, that should say 30th, not 20th. I apologize about that. And those are all in Lake Alfred, Florida. The registration is open for those. We will be closing the registration for the December course on December 10th. And just the prerequisite for that training is that you must have attended a PSA Train the Trainer course prior to attending one of our advanced trainer workshops. So we're really looking forward to those, and we hope that there's a lot of interest. So please do sign up for those trainings. And the registration link is on the screen and also posted on our social media and on our website. So with that, thanks again to Stephen for his awesome presentation today, and I think we'll wrap things up for the day, and happy holidays. We look forward to talking with you all again in January.
Absolutely. Thanks everyone for your time. Thanks again, Stephen.
Yep, thanks. That was great.
All right, take care, everyone.
Okay, yep, bye.